Have you ever pondered the critical role intellectual property rights play in our modern society? The journey of these rights has been a fascinating one, beginning with the adoption of the Universal Declaration of Human Rights in December of 1948 by the United Nations General Assembly. This monumental document consists of 30 articles, each pertaining to individual human rights. Article 27 in particular guarantees everyone the right to freely participate in the cultural life of the community, to enjoy the arts, and to share in scientific advancement and its benefits. Fast forward to the Paris Convention for the Protection of Industrial Property in 1883, a pivotal event spurred by an international exhibition of inventions held in Vienna in 1873. The exhibition faced hurdles as many foreign visitors were reluctant to exhibit their inventions due to the lack of adequate legal protection. Consequently, a conference was held in Paris in 1883, where 11 states signed the Convention for the Protection of Industrial Property. One of the cornerstones of this convention was the principle of national treatment. This meant that each member country had to offer the same protection to the nationals of other member countries as it did to its own nationals. Additionally, it introduced the right to priority, allowing applicants to file industrial property rights in other member countries within a 6 to 12-month period, while maintaining the original filing date. The convention also upheld the independence of patents, stating that the fate of a patent in one country would not influence its status in another. Next came the Patent Cooperation Treaty in 1970, signed in Washington, United States. This treaty facilitated international cooperation in the field of patents. Although it did not introduce the concept of international patents, it established an international system for filing patent applications, their publication, and preliminary examination. The Berne Convention for the Protection of Literary and Artistic Works in 1886, the oldest law in the field of copyright, aimed to protect the rights of authors in literary and artistic works as effectively and uniformly as possible. It introduced concepts like national treatment, automatic protection, and independence of protection. Interestingly, it also laid the groundwork for the protection of folklore, granting rights to a country if the author was unknown and there was reason to believe the work originated from that country. Finally, the Universal Copyright Convention of 1952, adopted in Geneva, Switzerland, was developed by UNESCO as an alternative for states who disagreed with the Berne Convention but still wanted to be part of a multilateral copyright treaty. Unlike the Berne Convention, the UCC provided copyright protection for a fixed renewable period and required copyright registration. In conclusion, the evolution of intellectual property rights has been a remarkable journey, from the Universal Declaration of Human Rights to the Universal Copyright Convention. These treaties and conventions have built a framework for the protection of inventions, artworks, and scientific advancements, fostering a culture of innovation and creativity while ensuring fair recognition and compensation for creators. This is the world of intellectual property rights, a world that continues to evolve in response to our ever-changing society.